Hello everyone and welcome to another edition of the Money Pros. I'm Oliver Tutt, Certified Financial Planner Practitioner, and I'll be your host for the next half hour as we talk about your money, how to make it, how to keep it, and hopefully how to help it grow. We've got a lot of stuff to get to on today's show. Let me give you a little idea of what we'll be talking about. Two of the segments are going to be somewhat related. Obviously, with a new presidential administration in place, there are going to be some changes, and some of the most significant changes are getting announced just now, and they impact consumer finances. So the first thing we want to talk about is the impact of President Trump's announcement that his administration plans to roll back Dodd-Frank financial regulation. We want to talk about how that might impact you as a financial consumer. And then in our third segment, we're going to be talking about a subject that we talked about several times here on the Money Pros, and that's the Department of Labor's fiduciary standards rule that was released last year. The Trump administration plans to take a closer look at that. So we want to take a look at the future of the DOL fiduciary rule. In between those two things, we're going to break it up a little bit, and we're going to talk to our estate planning pro, Bridget Delaney. She's an attorney and partner with Cameron Mittleman in Providence, and we're going to be talking about an important subject, and that is estate planning considerations for new parents. So we have that to look forward to. Having said all that, let's jump right into what we're going to be talking about today. And first thing I want to talk about is Dodd-Frank financial regulation. Now, Dodd-Frank regulations came out in July of 2010, and they were really the primary outgrowth of the primary regulatory outgrowth of the financial crisis that we all suffered through in 2008. And we've talked about this subject many times on the show. Bank collapses, insurance companies, brokerage firms, just a financial crisis across not only U.S. financial companies but globally, primarily triggered by real estate loans. So it was a crisis that was multifaceted, and the Dodd-Frank regulations, legislation followed by the regulations to back it up, were really an outgrowth of that. But there's been a lot of complaints about the Dodd-Frank regulations, as you might imagine, predominantly from Republicans and from Wall Street. And some of the criticisms really center around issues with respect to the size of the regulation. Dodd-Frank consists of 850 pages of rules and regulations, 850 pages. It consists of 400 separate rules. Some of the Dodd-Frank regulation hasn't even been enacted yet because they haven't quite figured out how to do it. But I want to talk about four of the major components of Dodd-Frank, and in particular how they affect consumers, because as a voter and a financial consumer, all of our viewers should be aware of how this regulation impacts you now and how the rollback of the regulation may impact you in the future. So let's throw up a slide, we'll talk about it. The first and probably the most important component of Dodd-Frank regulation was the creation of a new government entity called the CFPB. CFPB stands for the Consumer Financial Protection Bureau. And the Consumer Financial Protection Bureau, or CFPB, really was intended to centralize the accountability and protection for consumers in the financial services marketplace. As consumers, you deal with banks, brokerage firms, various types of lenders, credit unions, and all of those different organizations have different regulators. The idea of the CFPB was to consolidate a lot of that enforcement and regulation and give consumers one central place to look to in order to enforce laws, handle consumer complaints, and improve regulation. So big part of Dodd-Frank was the CFPB. You'll hear a lot about that. Next up with the Dodd-Frank regulation was derivatives regulation. Now, a lot of people would argue that derivatives were one of the central problems of the 2008 financial crisis. Mortgage-backed derivatives, people essentially betting on packaged mortgage products that they turned into derivative securities. So there was an effort with Dodd-Frank to seek to improve regulations for these under or unregulated products to make sure that they didn't cause problems in the future. Third thing on the list we want to talk about is crisis resolution. A big part of the problem with the 2008 financial crisis is the U.S. government did not have a good way to sort out troubled financial firms. FDIC is charged with sorting out banks. Securities and Exchange Commission was charged with sorting out brokerage firms. But regulations sought to find a way to centralize and make it easier to resolve firms in crisis and to step in quicker and to make it less painful for the consumers that are affected by the failures of these organizations. Final component is the regulation of credit rating agencies. Some of you may recall the press talking about how many of these derivative securities that we just got done talking about were in fact highly rated by various credit rating agencies like Standard & Poor's. But in fact, it turned out that many of these derivative sponsors were paying the credit rating agencies for higher ratings. So there was an effort to regulate that as well. So Dodd-Frank is a broad, sweeping set of regulations designed to protect consumers. You may or may not agree with how it was done, but as a consumer of financial products, and if you're watching this show, you certainly are at least paying a little bit of attention, you should be aware of what Dodd-Frank is and look to see what they in fact replace it with as they move forward with efforts to roll back that regulation. All right, up next, we're going to take a break from the political stuff. We're going to be talking estate planning with Bridget Delaney. Stay with us, there's more to come. Welcome back to the Money Pros. I'm joined now by our estate planning money pro, Bridget Delaney, attorney and partner with Cameron Mittleman. Great to have you on the show. Thanks for joining us.
Thanks for having me.
Great subject, by the way, to break up the sort of monotonous political talk that's going to bracket this segment. But this is an important topic. You know, we've talked oftentimes about estate planning on this show with your partners, among other people. And we usually, I find, talking about it in context of more senior people, retired and things like that. We're talking about passing assets on, making sure that you have control of your finances. Sometimes we talk about Medicaid and things like that. We're going to be talking about younger people at this point. So we want to talk specifically about estate planning for new parents. It's not so long ago that I remember being a new parent, although it's actually 18 years ago if I had my first kid, but it seems like just a few years ago. You have a lot on your mind when you're a new parent. Why is addressing your estate planning, generally speaking, something that these new parents should actually move to the top of their agenda?
And certainly when you are a new parent, you have a lot on your mind and no one really wants to think about dying, particularly when you have a young baby at home. But I think it's important because it gives you peace of mind that your child, if something were to happen to you, would be financially and emotionally provided for.
So we're going to step through some of the fundamentals of an estate plan. And these, I think, are, we talked about them on the show before, they're building blocks for any estate plan. But we want to talk about why they're particularly important to new parents and what role these various devices will play in an estate plan for new parents. So let's put up the slide and we'll talk about them here one by one. And the first is a will. I think most people understand what a will is, at least in some sort of general context. But as it relates to new parents, why is a will such a critical document for them?
I think the most important reason that new parents need a will, or parents with minor children, is to name a guardian for your children. If you don't name a guardian for your children, you're leaving it up to the courts to make that decision for you.
And do you find that it's hard for new parents, or any parents in general, but to pick a guardian? I know it was something that my wife and I wrestled with, and it wasn't for lack of choices. I think sometimes when there's a lot of choices, it makes it difficult. But do you find it's hard for a lot of parents to make that choice, and what advice do you have for them to help them make it easier?
Yeah, it's very difficult to make the decision about who's going to care for your child if you're not there. And I often find that parents will delay making a will or even signing a will because they can't even agree amongst themselves who's going to be the guardian. And what I like to tell parents when they come in is, you know, think of the next 3 to 5 years. Changing a guardianship provision in a will is relatively easy to do. So it's something you can always change. And then you want to kind of look at, for any potential guardian, what their age is, what their health is, where do they live? Are they across the country? Are they in the same town? And then what are their parenting philosophies? You know, and as I said, it's not an easy decision, but I think it does give people peace of mind to know that they can change it, and it's always better to name someone as opposed to leaving it up to the courts to make that decision.
And I'm curious, as part of that process, what would your advice be? And honestly, this question's a little bit self-motivated, but because I find myself in this situation. If you have children, or in my case, my youngest is 10, and would clearly need a guardian, but my oldest is legally an adult, are there situations where it actually makes sense to name an older sibling as the potential guardian?
Yeah, certainly you can. I mean, depending on what the age of your oldest child is.
And their level of responsibility, I imagine,
mean,
and things like that.
You can have a very mature 18-year-old, who could maybe handle that. But, you could also have an 18-year-old who's not really at that level. But, there's big age ranges in families. So if you have your oldest child is 25 and you have a child who's 16, that may be an appropriate situation. So I think you have to look at every individual family.
I think my other 3 children would worry that I was putting their life in danger by placing it in the hands of their oldest sister. So the will is clearly going to be a critical document for new parents. Let's talk about another document that, honestly, when I was looking at this list, I was thinking, really? A trust? Why is that important? So trust, again, something we've talked about a lot on this show, but more in the context of seniors and retired people for a variety of different reasons. Why would a trust be relevant to a younger family with new kids?
Yeah, certainly people oftentimes when I suggest a trust, they assume that you have to have a certain level of wealth to do that, which most people when they're young and just starting off don't have that wealth.
Right.
But it is important when you take into account that you have life insurance and retirement accounts, which, although they're not readily available to you now, when you pass away, those are going to be liquid assets. And a lot of times you can have a lot of wealth in that, and you don't want to leave that to your children outright because it would get stuck in the probate court proceedings and in all likelihood would be distributed out to the child at 18, which most people think an 18-year-old is not mature enough to manage, $500,000 or whatever level of assets.
Right, they might be able to take care of the younger siblings, but they definitely can't have all the money. I think that would be a mistake.
Yeah.
Would you advise, and I imagine it depends on the circumstance, right? But generally speaking, the difference between setting up a trust while the parents are alive, I'm imagining a revocable living trust, versus a testamentary trust that's not established until or unless both parents pass away. I mean, how do you find you're making that decision about how to advise a client?
I think generally I try to tell people, I mean, it's typically simpler to have a standalone trust as opposed to having it under the will. A will is not a private document, so it also means that anyone can go look at that when you pass away. It's in the probate courts. So I do think from a standpoint of simplicity, privacy, it's easier to have a standalone trust. Certainly, you can have it under one document, and some clients in their mind think it's simpler, and that's certainly fine.
And I know something that comes up from time to time is the decision that we just talked about with respect to selecting a guardian for the child is a different decision than selecting a person to be the guardian for the assets, which we would call the trustee, I think, in this circumstance. Are they usually the same person? Are they often different people? What advice do you have for selecting that role player in the estate plan?
Yeah, certainly the guardian and the trustee do not need to be the same person, and in some circumstances it's appropriate to have different people. The person who you trust really to make the day-to-day decisions about your child, where they're going to school, their healthcare decisions, how you're disciplining them, may not be the person who's also great with money. Or it may just be too much of a burden to have on one person to handle the financial matters as well. So, you might have someone else separate who's the trustee. And I always just suggest that you have the guardian and trustee be able to communicate with one another and have a decent relationship. You certainly wouldn't want to name, if you're naming, let's say, siblings of yours, to be one to be the guardian, one to be the trustee, if they don't like each other.
You don't want it to be an antagonistic relationship, but it could be a good check and balance in the right circumstance, I guess. Next on our list, we have beneficiary designations. Now, this is one I've seen this screwed up a lot of times. It's amazing, I think, how many times you find newlyweds, and they're not so newlywed anymore, and you find out, like, mom is still a beneficiary on the husband's retirement plan. But why is this an important thing to look at?
Similar to when you get married, it's the idea that you want to review your beneficiary designations whenever there's any change in your family. And when you have children, that's certainly a major change, and you want to make sure that they're still accurate. And particularly with life insurance and retirement accounts, oftentimes naming a child directly either as a contingent beneficiary or the primary beneficiary is not appropriate. It can tie the money up in probate court, and you can't control when they get the money. So in some instances, it makes more sense to name a trust for the benefit of the child, or a trust for the benefit of your children as the beneficiary.
So the beneficiary designations can get complex, and I think as with any of this stuff, it really all needs to be coordinated. It's not as if you can say, all right, I'm going to do the will this year, and then 3 years later I'm going to think about a trust and things like that. Last thing on our list is powers of attorney. What role does this play in the estate plan for new parents?
I think just for any person, it's very important to have a financial power of attorney and a healthcare power of attorney. The financial power of attorney is when you're appointing someone to make decisions for you for legal and financial matters. And, in the same with healthcare, you're appointing someone to make decisions for you for healthcare matters if you can't. And in the event that you are unable to make decisions, let's say you're in a car accident or something happens and you're unable to make those, you want someone to be able to continue to pay your mortgage, to be able to pay, your kids' tuition. So I think it's just important to have those in place.
And about 20 seconds left. One of the things you mentioned to me before the show started was travel authorizations. What role does this play in the bundle of documents we've been talking about?
Yeah, so parents often travel for the first time without their kids, and that can be a big decision.
Stressful.
Stressful. I just recently did that. So oftentimes you can leave the person who's caring for your child. You can essentially make them the temporary custodian for the child and allow them to be able to make medical decisions for your child if, God forbid, your child's hurt when you're away.
Right. So that's an important consideration. Stressful for some. I was running out the door the first time I had the opportunity to go away without my kids, but don't tell them that. Bridget, thank you. Very valuable information. I appreciate
you're welcome.
it. All right, stay with us. Next up, we're going to be talking about the future of the DOL fiduciary rule. There's more to come here on the Money Pros. Welcome back to the Money Pros. So as we talked about in the first segment, there's been a flurry of activity at the White House with Donald Trump and executive orders, and a lot of them relate specifically to financial industry regulation, and it's important that people understand how that will directly impact them. So I'm not advocating for or against any of these rules particularly, but I think it's important that consumers understand what's going on. And one of the things we've talked about a number of times on this show has been the Department of Labor's fiduciary rule. Now, this is not a law, but a rule put in place by the Department of Labor after a lot of research and public comment that impacts how financial advice is delivered to consumers. For most of the history of my industry, financial advice was delivered, and the standard of care to which the financial advisor was held is called one of suitability, meaning that the advice should merely be suitable. It doesn't have to be the best possible advice. And suitability is a very low threshold, and typically what comes with a suitability threshold is the ability for the advisor to receive commissions. Now, a higher threshold of care is known as fiduciary care, and that is that the advisor should provide the highest and best possible advice, that it can't just merely be suitable, but it's got to be the best option. The Department of Labor came along and said that if financial advisors are going to advise on retirement plans, that they're going to have to provide a fiduciary level of care. And this is an earth-shaking change in the financial services industry because it really eliminates commission-based business from a lot of this. So let's talk about the DOL's fiduciary rule and talk about the various components. First off, what types of accounts does it actually impact? Well, Department of Labor actually regulates, among a lot of other things, retirement plans. So this impacts your 401ks, 403bs, 457 plans, all of those plans that you've probably heard of before. And it also impacts IRAs. So if you have a financial advisor that is offering advice on those types of accounts, the Department of Labor fiduciary rule would require them to be held as fiduciaries. It also makes it very difficult for them to do business on a commission-based way. And we'll talk about that in a little bit. Next part of the fiduciary rule, specifically the fiduciary standard. So the suitability standard is no longer sufficient on these types of accounts, that the advisor would actually be held to a fiduciary standard, meaning that whatever advice they offer to you, the consumer, has to be the highest and best advice. It can't merely be suitable. It puts a lot more responsibility on financial advisors. And finally, there's something that's called the BICE, or Best Interest Contract Exemption. It puts in place the one loophole for advisors to be able to continue to do commission-based business, which requires the client to actually sign a contract acknowledging that the broker is working on a commission-based methodology and would actually require them to disclose the commissions. So that's how the DOL fiduciary rule works. The reality is the Trump administration and most Republicans are not wild about this, and certainly Wall Street is not particularly wild about this. And so Donald Trump has issued an executive order requesting the Department of Labor re-examine the rule, and he's extended the deadlines for the rule to be put in place. Prior to this, the rule was expected to be put in place fully on April of 2017. Donald Trump's executive order has made it, has requested that the Department of Labor re-examine the rule to ensure that it is in fact the best thing for consumers, and has given the Department of Labor permission to delay the implementation of the rule. Many people suspect this is to give time for the new Secretary of Labor to get into office and make his own decisions about how the rule will be enforced. The next wrinkle to this was, in fact, that Donald Trump's pick for Secretary of Labor, it was just announced today that he had withdrawn his name for consideration. So as this is being taped, we don't even know who the new head Secretary of the Department of Labor is going to be. The DOL fiduciary rule is really critical. Pay attention. It's important for consumers to understand how their advice is being delivered and how they are paying for that advice, and that is currently in a great deal of flux. All right, up next, we're going to be talking about how you can ask the Money Pros a question. We're going to give you the details, and we want to encourage you to do it, so stay with us. There's more to come. This show marks the conclusion of the 6th season of the Money Pros, and it's hard to believe that it's actually been 6 years that the show has been on. And over that time, we've received a tremendous number of questions from our viewers. Our viewers have access to all of our Money Pros. All you have to do is get in contact with us, and we answer all of our questions. You can get in touch with us 3 ways. You can visit the Money Pros on Facebook, you can visit foxprovidence.com and click on the Money Pros, or you can email us moneypros@foxprovidence.com. Send us your questions. We'll get you the answers. As always, thanks for joining us on the Money Pros. We'll see you again next time. Take care, folks.